Thank you for joining us for our summer meeting. I hope you all are taking time out with your families and are enjoying the summer thus far. I want to begin with approval of the minutes. Has everyone had a chance to review the minutes from May?
Yes.
Yeah. Has everyone had a chance to review the minutes from May?
Yes.
Yes.
With that,
Yes.
Move to approve.
thank you. I'll have a motion to approve the minutes.
I
Second.
second it, ma'am.
Thank you. All those in favor?
Aye.
Any opposed?
Aye.
Any opposed? Thank you. Motion carries. The minutes for May are approved without any amendments.
Judge Milton, if it's okay with you, I can just give a little introduction with regard to the next agenda item.
Yes, that's fine.
Okay, great. We're on agenda item 4, which is the proposed amendments to the December 2nd public comments hearing. On May 31st of this year, the Sentencing Commission received an email from one of the individuals who spoke at the Commission's December 2nd, 2025 public comments hearing. The individual, Shaughnessy DeBerry, expressed concern regarding those public comment hearing minutes. Specifically, Mr. Berry requested that the minutes identify her by name. The MSCCSP responded that the Sentencing Commission public comment hearing minutes do not identify public speakers due to a policy enacted in 2017 after an individual and a family who had testified at a prior Sentencing Commission public comments hearing were later harassed by an individual who found their testimony online. This policy is referenced on page 9 of the Commission's December 11, 2017 meeting minutes. After hearing from the individuals who were harassed and removing their testimony from the website upon request, the Commission adopted a policy pertaining to testimony received at the annual public comments hearing. The policy indicates that no individual testimony or personal information will be published on the Sentencing Commission's website. Instead, a summary of testimony is included in the public comments hearing minutes published on the website. Additionally, the adopted policy requires the Commission to redact personal information related to private citizens that is contained in any testimony. Name, job title, and agency remain unredacted in testimony provided by individuals who provide testimony on behalf of government agencies. It was explained that the minutes followed the Commission's previously established protocol, and that is why only one speaker, Ms. Hilliard, providing testimony on behalf of the Office of the Public Defender, was identified by name in the December 2nd public comments hearing minutes. The policy was enacted to protect the identity of individuals who speak at the public comments hearing in a personal capacity. The Sentencing Commission policy to exclude name and identifying information for public speakers was adopted in 2017, at which time there was no video recording of the Commission meetings and/or public hearing. Given that the meetings are now recorded and archived on YouTube, it may be appropriate for the Sentencing Commission to revisit this policy. The staff plans to present this issue to the Guidelines Subcommittee for further review at a future meeting. On June 19, 2026, a second individual, Mr. Marcus Snipes, also requested that the public comment hearing minutes identify him by name. Per Mr. Berry and Mr. Snipes' requests, we now present proposed amendments to the December 2nd public hearing minutes to identify both speakers by name. The amendments are reflected on pages 5 and 6 of the amended minutes that we sent to you. Mr. Snipes additionally requested a more detailed summary of his comments. The staff responded to his email indicating that the meeting minutes are intended to provide only a brief summary of the testimony rather than a full transcription. Additionally, it was noted that the minutes include a link to the live stream video where the full testimony can be viewed. Accordingly, the amended minutes do not include any more detail beyond the summary already provided. So I present that discussion and the proposed amendments, the proposed amended minutes for your review.
All right. The December minutes were with the proposed amendments were also sent. Did everyone have a chance to review those?
Yes.
I just want to make sure. All right. Is there a motion to approve the amendments to the December minutes with the amendments? Or did I already say that? Is that a motion? So moved by Judge Shaw. Is there a second?
Second.
I'll second.
Thank you. All those in favor?
Aye.
Any opposed? Mr. Harvey, you opposed?
Yes, I mean, the policy is
Any discussion?
not, policy is not to put the names in. I think we're putting the cart before the horse. Shouldn't we change the policy before we publish the names?
Okay.
That's my position.
All right, so now there's discussion. Thank you. Judge Shaw?
Um, I think that we can go ahead and vote, but I also think that I agree with Mr. Harvey that we may want to rethink and just say that that is our policy. But if an individual specifically wants to have their name identified, that we should do it. We're trying to protect someone who doesn't feel that they need to be protected. They want to be identified. And so I think that the policy should be amended, that we will continue to do what we have been doing all along. But if someone wishes to be identified by name, that we agree that that can be done.
Yeah, I'll second, if that's a motion, I'll second that.
Well, the original motion already carried. There's only one person who opposed it. So the original motion does carry.
Yeah, but we're talking about
Is it
moving
a-
forward.
Right. So, but first, I have to state that the original motion carries. Now,
That's noted, right?
yes. So is there a motion to adopt a new policy then, or to amend the current policy?
That's what I thought I was trying to do.
Okay.
So
That's fine. We could address it right now. That's
my motion is that we amend our policy to read that if a person specifically, I don't want to say specifically, but if a person indicates that they wish to be identified by name, that the commission will allow that. Mr. Harvey, you seconding?
Second,
Is there any discussion?
I have a question. So if that person is coming and they're speaking about another individual, do we have to get that other person's permission for their name to be in their uh, substantive discussion? I think that the slope goes both ways because that other person may not want their name
Yeah.
mentioned. So we would have to address and get all parties to agree to have their name put. It's just, that's my thought.
Yeah. That's
I
an excellent
absolutely
point because that's very similar to the scenario as it first happened back in 2016. So I think that's an excellent point by Mr. Johnson.
I absolutely agree that
Yeah.
my motion would be only as to the individual who wishes to be identified. And if they are testifying as to other individuals, those individuals could not be identified. So I don't know how we would handle that. We would redact it. We would say that they're testimony could not be used because they identified other individuals who do not agree to that.
So
Well-
would that be in a written consent or an oral consent? Like, would they have to put it on the record as they are speaking, or how are we documenting who and when and in case?
I think with the information that goes out to the speakers about time,
Right.
place, and all of that, that we can
Right.
have a document that says that it is the policy of the commission that we do not identify speakers by name. If you would like to be so identified and explaining that it extends only to the individual who is speaking, a situation similar to what Mr. Johnson was referring, and that the person would have to send back or email, a document saying they wish to be identified by name, and we would have that for whatever purposes we may need in the future.
Okay, thank you.
But I guess at this juncture, since it's all being recorded and it's all live, aren't they already sort of being identified? I mean, they're already sort of being identified on the live stream. I think the problem more is if somebody says they don't want to be identified and then they're on the live stream.
Well, if you
out
agree to be on the live stream, you kind of agree, you give
Yeah.
up some of your privacy.
Right, but what if so you're saying if somebody comes and they want to give testimony, they have to agree to be identified?
No,
Because by name, well, I guess when a person testifies, do they, I guess they do start off by saying their name,
Generally, so
Yeah.
but they don't
Yeah.
have to.
so that's one of the points. I was just going to make that point. That is one of the points that the commission made when they responded in their email. And when they responded to their email, the fact that
Yeah.
these meetings are different because they're now recorded. But
Right.
the point being is that later requests for their identity to be disclosed still need to be made by the individual. They will have to take into consideration whether or not their identity is going to be disclosed should they wish to speak in public on these Zoom meetings. I guess that's something they need to think about now. And maybe well, that's something that they have to consider now.
so when people come and they give testimony, are they told this is all being live streamed, it's on YouTube?
Yes.
They know all that beforehand?
Yeah.
Yep.
Yeah. And that's what I was thinking. I think this can all be addressed with just some simple amendments to the invite that we sent out asking for speakers and that we post to the Sentencing Commission's website, just making it, I mean, that already talks about it being live streamed, but making it clear that it's live streamed and that they understand that, and that and that there will be minutes. And if they want to be identified by name, they have to, indicate that when they email us to sign up to testify.
Have you, just out of curiosity, have you ever had anybody who said that they don't want to necessarily be live streamed?
Not as of yet, no.
I was just curious.
I mean, these are public meetings,
Right.
and that is the expected standard now to live stream these meetings. So, but to answer your question, no one said I don't
I guess I was just thinking you might have a domestic violence victim who doesn't necessarily want to
I
be
get that.
on a
Yeah.
live stream,
Right.
but they have something that they want to say. So I was just
But
curious
maybe
about
if we could address that in advance and if they participated virtually, they could do so off camera. And make sure, there's a way in Zoom where you could even have their name not appear as their name. They could write anonymous, you could change the name. So I think we could address that if we know in advance. I see Ms. Guarino's hand up.
Thank you, Dr. Souley. I do feel even though there is now a different level of transparency due to the online recorded nature of these meetings, that it is still worthwhile to provide individuals who are testifying the opportunity to not have their name listed, if for no other reason than search engines may be more likely to pull up the associated testimony if it is in written form. I know that's not necessarily, I think, a durable barrier in the world that we live in. But for now, it is still one level of anonymity that may incentivize individuals to be more likely to come and engage and be able to have their voices heard. And I think it is worthwhile to still keep the presumption of protecting their privacy unless otherwise requested.
I would suggest, Judge Milton
I
and,
would-
and everyone, that maybe what we could do here is hold off on voting on this particular motion. The staff could draft language for the instructions that we would send out and post on our website to kind of account for all these factors that we discussed here today, and that the commission could look at them and discuss them at our September meeting. So we would have them ready before the December public comments hearing.
Okay. All right. Does everyone agree to kind of table this until we have more time to gather language and information?
Yes.
I
Agreed.
personally feel that we're ready to vote on it.
Okay.
And that the implementation of it is something that we can work on and talk about in the fall. But I think that it's important for us to move forward and say that we will continue not to identify people unless they specifically request. So the motion is on the
There's
floor.
right. There still is that motion on the floor.
Okay.
All those in favor of the motion? Any opposed? The motion carries.
Okay. Yeah. No worries.
So I still think that the staff can move forward with
Right.
developing guidelines. Yes.
Okay. Sounds good.
Next is the proposed classifications of new and revised offenses.
I'm going to defer to Judge D. Leonardo because I had technical problems last time and
I read the minutes. Okay.
it was horrible.
Yeah, and I'll certainly defer to Dr. Soule to let him go ahead and lay out what all we covered.
Okay.
Yeah, I'm happy to do so. So I'll begin the proposed classification just by discussing, I like to do this every year, how the commission traditionally classifies new and revised offenses, and provide a quick explanation of what is covered in the materials that we sent for this meeting. So each year, the commission reviews new and revised criminal penalties and considers how the new or amended criminal penalties will fit within the Maryland sentencing guidelines. The task of classifying this is designated to the guidelines subcommittee, and these classifications are then presented to the full commission for review, which is what we're doing today. In preparation for this task, the staff reviews all legislation from the session, the most recent session, and prepares a memorandum that identifies any new or amended offenses that carry a maximum penalty of greater than 1 year. The memorandum focuses on penalties of 1 year or more because by rule, the commission does not require classification of offenses that carry a maximum penalty of 1 year or less. Rather, these offenses are automatically assigned the lowest seriousness category, which is a seriousness category 7. I refer you to the memorandum labeled Proposed Classification of New and Revised Offenses. This is a 42-page document, but we don't have to go through every page by page, but I'll kind of guide us through which ones we need to vote on. Those will be the ones at the beginning. So it's new. There's 4 sections. There's new offenses with recommended action, changes to existing offenses with recommended action. Then there's new offenses with no action recommended, and changes to existing offenses with no action recommended. So we'll be focusing on those that have recommended action. For your reference, we also provided a supporting document labeled Combined File of Legislative Text for New and Amended Offenses. Hopefully you all saw my warning about the length of this document and didn't automatically print it out. It is a PDF that combines all the legislation that is reviewed in the new and revised offense memo. The bills appear in the order that they are listed in the memo. And for your convenience, on the first page, there is a table of contents that is clickable. So if we're talking about a particular bill, you can just click on that and it'll bring you to the appropriate page in the document. Based on the commission's protocol, the subcommittee offers seriousness category classifications by examining currently classified offenses that are comparable based on the following factors. First, the type of offense, whether it's person, drug, or property. Second is the statutory maximum penalty. Third is the misdemeanor felony classification. And finally, when possible, the nature of the offense. For each new or amended offense, the memorandum presents guideline subcommittee identified comparables at the bottom of each page or on the following page. So to go through this, we'll go through in order and we'll start on page 1 with chapter 662, 663, which is related to House Bill 216, Senate Bill 140. This legislation prohibits a person through deception, coercion, exploitation, or isolation from knowingly recruiting, harboring, transporting, or obtaining an individual for the purpose of appropriating the government benefits of an individual for their personal benefit or for the benefit of another. A violator is guilty of a misdemeanor and subject to imprisonment not exceeding 1 year or a fine not exceeding $500 if the aggregate value of the government benefits is less than $1,500. A violator is guilty of a felony and subject to a fine not exceeding $10,000 and or imprisonment not exceeding 5 years if the aggregate value is at least $1,500 but less than $2,500. A violator is guilty of a felony and subject to a fine not exceeding $15,000 or imprisonment not exceeding 10 years if the aggregate value is at least $25,000 but less than $100,000. If the aggregate value of the government benefits involved is $100,000 or greater, a violator is guilty of a felony and subject to a fine not exceeding $25,000 or imprisonment not exceeding 20 years. The comparables are identified on page 2 of this memorandum, and based on these, the guidelines subcommittee recommends classifying all 3 violations as property offenses with a seriousness category of 7 for the 1-year misdemeanor, a seriousness category of 6 for the 5-year felony, a seriousness category of 5 for the 10-year felony, and a seriousness category of 3 for the 20-year felony. And I'll ask for a vote on each of these ones that are requiring recommended action. Any discussion with respect to chapter 662, 663?
Well, then I'll move to adopt the recommendations of the subcommittee.
Second.
I think I saw Delegate Bartlett and Rick, so thank you both.
Any opposed?
Okay, great. Adopted. Moving on to page 3, we continue with chapter 429, which related to Senate Bill 512. Senate Bill 512 prohibits a person who has a protective or court order against them from stalking the individual who is a subject of the order or from stalking any individual following a previous stalking conviction in Maryland or in any other state. A violator of this offense is guilty of a felony and is subject to imprisonment not exceeding 10 years and or a fine not exceeding $10,000. Based on the comparables, which are listed on page 4 of the memorandum, subcommittee recommends classifying this violation as a person offense with a seriousness category of 4. Any discussion?
Thank you. Is there a motion to adopt the recommendation of the staff to adopt the seriousness category of 4?
I saw Mr. Fincy and then Judge Saunders. I'll put as a second.
Thank you. All those in favor?
Aye.
Any opposed? Motion carries.
Okay, moving on to page 5. We will continue with chapters 520 and 521 related to Senate Bill 482 and House Bill 593. This legislation prohibits an individual from intentionally, willfully, and without authorization committing an act prohibited under Section 7-302 of the criminal law article that denies access to an authorized user of or interrupts or impairs the functioning of a critical infrastructure or a public safety answering point. A violator is guilty of a felony and subject to imprisonment for up to 10 years and or a fine of up to $50,000. The bill also amends a violation of criminal article section 7-302 subsection D5 to require that the action be taken intentionally, willfully, or without authorization, and adds to the list of prohibited actions the intent to interrupt or impair the functioning of a critical infrastructure. So we don't need a vote on that second listed offense because that's already classified. We were just noting for our own recommendations, for the staff notations, the non-penalty changes that occurred to 7-302D5. The comparables for this are shown on page 6, and the guidelines subcommittee recommends classifying the new 10-year felony as a property offense with a seriousness category of 4. Any discussion?
Thank you. Is there a motion to adopt the recommendation of the staff?
I'll make the motion.
Thank you. Is there a second? All those in favor? Thank you, Miller. Thank you. All those in favor? Any opposed? Thank you. Motion carries.
Great. Moving on to page 7. We'll continue with chapters 456 and 457 related to Senate Bill 437, House Bill 752. This legislation prohibits a person from altering or tampering with a gift card with the intent to defraud another. A violator is guilty of a misdemeanor and subject to imprisonment not exceeding 18 months and or a fine not exceeding $500. The comparables are shown on the bottom of page 7. The subcommittee recommends classifying this offense as a property offense with a seriousness category of 7.
Thank you. Is there a motion to adopt the recommendation? Thank you.
Delegate Bartlett.
Thank you, Delegate. Is there a second? Thank you, Judge Saunders. All those in favor? Any opposed? Thank you. Motion
Okay,
carries.
so that carries. Moving on to page 8, we continue with chapters 401 and 402 related to Senate Bill 360 and House Bill 563. This legislation repeals the prohibition against intentionally inflicting bodily harm, permanent disability, or death on an animal owned or used by a law enforcement unit, which is a felony, formerly aggravated cruelty to animals under Criminal Law Article 10-606. This bill instead establishes misdemeanors that, 1, more broadly prohibited, except in the case of self-defense, specified intentional harm to, harassment of, or interference with an emergency response animal, which is defined as a dog or horse used by a law enforcement unit or in search and rescue efforts. And second, are subject to a broader range of criminal penalties. Just so you know, we included the 1-year maximum incarceration penalty here so we could review the full range of penalties together for the statute at the same time. The comparables are shown on page 9. The guideline subcommittee recommends classifying both offenses as property offenses with a seriousness category of 7 for the 1-year misdemeanor and a seriousness category of 6 for the 2-year misdemeanor.
Thank you. Is there a motion to adopt the recommendation? Thank you, Mr. Finchie. Is there a second? Delegate Bartlett, thank you. All those in favor? Thank you. Any opposed? Motion carries.
Okay. Moving on to page 10. We continue with chapter 547, House Bill 564. This legislation establishes the Maryland Pet Cremation and Burial Services Consumer Protection Act under both Title 5, Subtitle 7A of the Business Regulation Article and Title 7, Subtitle 4B of the Health Occupation Article. The act requires disclosure of pet cremation services from registered cemetery workers and cemetery licensees, accurate description of cremation types, compliance with federal and state laws that protect the health of all individuals responsible for handling pet remains, retention of complete and accurate cremation records for at least 5 years, maintenance of confidentiality and security procedures for records and personal identifying information, and provisions of certificates when remains are returned. A violator is guilty of a misdemeanor and subject to imprisonment not exceeding 1 year or a fine not exceeding $5,000 for a first offense, 2 years and a fine not exceeding $10,000 for a second offense, 3 years or a fine not exceeding $15,000 for a third or subsequent offense. We again included here the 1 year maximum penalty so we could review the full range of penalties for the statute at the same time. Based on the comparables, which are shown on page 11, the subcommittee recommends classifying all 3 violations as property offenses, a seriousness category of 7 for the 1 year misdemeanor, a seriousness category of 7 for the 2 year misdemeanor, and a seriousness category of 6 for the 3 year misdemeanor.
Is there a motion to adopt the recommendation? Thank you, Judge Shaw. Is there a second? Thank you, Judge Saunders. All those in favor? Any opposed? Motion carries.
Okay, moving on to page 11, we continue with Chapter 444, Senate Bill 141. This legislation prohibits an individual from knowingly or with reckless disregard creating, using, or disseminating a deep fake to produce material false information and generally relating to election misinformation, election disinformation, and deep fakes. A violator is guilty of a misdemeanor and subject to imprisonment not exceeding 5 years and or a fine not exceeding $5,000. The comparables are identified on on the bottom of that same page, on page 12. The subcommittee debated between a seriousness category of 6 or a seriousness category 7 for this offense. The subcommittee focused on election law article 16-201, which is the third listed comparable. This legislation prohibits a person from willfully and knowingly impersonating another person in order to vote or attempt to vote under a false name. It lists several other activities, including voting more than once for a candidate for the same office or on the same ballot question, voting more than once or attempting to in the same election, or voting in more than one election district or precinct, voting in electric district or precinct without legal authority to vote there, attempting to influence or influencing a voter's decision through the use of force, threat, menace, intimidation, bribery, reward, or action engaging in conduct that results or has the intent to result in the denial or abridgment of the right of any citizen of the U.S. to vote or on account of race, color, or disability. Based on this specific comparable, which I just described, that's election law article 16-201, the subcommittee thought that was relevant. The subcommittee thought that this classification would imply that the seriousness category for the new offense would also be a category 7, with the only difference being that the new offense sounds like it is intended to impact other voters. Ultimately, the subcommittee chose to recommend classifying this offense as a property offense with a seriousness category of 7.
I did note that there was some spirited debate, and I did appreciate the way it was captured in the minutes. It did help to bring some clarity to it. Okay, is there a motion to adopt the recommendation? Is there a motion to adopt the recommendation? Thank you, Judge DeLeonardo. Is there a second? Okay, Mr. Harvey. All those in favor? Any opposed? Motion carries.
Okay. Moving on to page 13, we continue with Chapter 530, Senate Bill 221. This legislation prohibits child pornography with 100 or more images, and generally relating to child pornography prohibitions and penalties. A violator of the 2 offenses listed here is guilty of a felony and subject to imprisonment not exceeding 10 years. A sentence imposed for these acts may be separate from and consecutive to, or concurrent with the sentence imposed for any other crime based on the act establishing a violation of criminal article 11-207 or 11-208. 207 is the child pornography, and 208 is possession, retaining, viewing, visual representation of a person younger than 16 engaged in sexual acts. So it's the staff's understanding that this particular legislation and these offenses are essentially enhancements for the regular child pornography offenses. We have the identified comparables that are on page 14. Based on these, the subcommittee recommends classifying these offenses as person offenses and the seriousness category of 4.
Is there a motion to adopt the recommendation? Thank you,
Mr.
Mr. Johnson. Is there a second?
Vincent.
Thank you. All those in favor? Any opposed? Motion carries.
Okay. We are moving on to page 15. We continue with chapter 233, 234, and this is related to House Bill 374, Senate Bill 370. This legislation prohibits an individual from employing a person to practice acupuncture without a license or aiding or abetting the unauthorized practice of acupuncture. A violator is guilty of a misdemeanor and subject to imprisonment not exceeding 1 year and or a fine not exceeding $5,000 for a first offense. For a subsequent violation, individual is guilty of a felony and subject to imprisonment not exceeding 5 years and or a fine not exceeding, does that say 5,000 a day? 5,000 a day. Maryland law currently prohibits an individual from practicing acupuncture without a license or falsely representing themselves as an acupuncturist, though the commission has not yet classified this offense. So we decided to include it here. The staff included, was that health and occupation article? Do I have that correct? 1A-404B1. That's the third offense listed in this table, even though it carries, sorry, it's the second offense listed in this table, even though it carries a
1 year.
a 1-year penalty. And we did this again so we can consider them all, the full range of penalties at the same time. The comparables are identified on page 16. Based on these, the subcommittee recommends classifying all 3 offenses as person offenses with a seriousness category of 7 for the 1-year misdemeanor, seriousness category of 6 for the 3 and 5-year misdemeanors. So I'll present those as the recommendations of the subcommittee.
Is there a motion to adopt the recommendation? Judge
Judge
Shaw?
Shaw.
Second, is there a second? Judge Saunders. All those in favor? Any opposed? Motion carries.
All right, moving on to page 17, we continue with chapter 445, Senate Bill 8. This legislation adds the use of artificial intelligence or deepfake representation to prohibitions against identity fraud. The bill prohibits an individual from knowingly, willfully, and with fraudulent intent using AI or a deepfake representation to cause harm to another by impersonating, falsely depicting, or claiming to represent another person, or to create or distribute false records with the intent to cause harm to another, induce another to provide personally identifying information, or obtain a benefit, credit, good, service, or other thing of value. A violator is guilty of a felony and subject to imprisonment not exceeding 5 years and or a fine not exceeding $10,000 for 1 victim. This is the first offense listed in the table. For 2 or more victims, a violator is guilty of a felony and subject to imprisonment not exceeding 10 years and or a fine not exceeding $15,000. This is the second offense listed in the table on page 17. Senate Bill 8 also prohibits a person from knowingly, willfully, and with fraudulent intent using the personal identifying information of another without their consent to cause harm. A violator is guilty of a misdemeanor and is subject to imprisonment not exceeding 1 year and or a fine not exceeding $500. This is the third offense listed on the table. Finally, Senate Bill 8 prohibits an individual from knowingly and willfully assuming the identity of another without their consent to cause harm. Knowingly and willfully assuming the identity of another, including a fictitious person with fraudulent intent to harm, harass, intimidate, threaten, or coerce the other person. This is the fourth offense that's listed on the table, or it's the first offense listed on page 18. Based on the offense description and the varying comparables that are listed and identified on page 19, the staff was undecided at first on whether the first, second, and third offense listed on pages 17 should be property or person offenses, or whether the commission may choose to offer a dual offense type classification as either a property or a person offense. In 2025, some of you may recall the commission decided to employ a dual classification option, and that was person or property, for the offense type for Election Law Article 16-205, which is interference with performance of official duties by an election official, an individual present at polling place, or canvass of votes. The instructions for that offense note that petitioners have the discretion to select whether the offense is a person or a property offense based on the specific facts of the case. If the state and the defense disagree as to the offense type, they are instructed to bring that disagreement to the attention of the judge at sentencing. The guidelines subcommittee believe the same dual classification is appropriate here because the offense could be committed to cause harm directly to a person and or to unlawfully obtain property. Harm is defined on the second page of Senate Bill 8 as physical injury, serious emotional distress, or economic damages. The guidelines subcommittee discussed examples of someone using AI to create a realistic image depicting a sexual act of another. The group also discussed the Pikesville High School principal situation where an individual used a deep fake recording of the principal saying racist remarks. These examples involve direct harm to others, but are not traditional in-person confrontations. On the other hand, no one would reasonably describe either of these two examples as property offenses, which is defined as an offense where property is unlawfully damaged or taken. The staff identified two or more recently classified offenses that do not involve a traditional direct confrontation between the offender and the victim. Those two offenses are first, publishing personal information of a protected individual, knowing that publishing that information poses a threat to a protected individual. And that was from the judge, Andrew Wilkinson, Judicial Security Act of 2024. And also the second example we thought of was revenge porn under Criminal Article 3-809. The commission chose, correctly, I believe, to classify those offenses as person offenses, even though they do not involve a traditional confrontation. Given these comparisons, the subcommittee believes a dual classification is appropriate for these new AI/deepfake offenses. Regarding the seriousness category classification, the guidelines subcommittee recommends classifying the 5-year felony as a seriousness category 6, the 10-year felony to be a seriousness category 5, and the 1-year misdemeanor to be a seriousness category 7. Finally, regarding the fourth offense in this table, which is listed, the first one listed on page 18, which is just a reminder that's representing self as another with intent to harm, harass, intimidate, threaten, or coerce. The subcommittee recommends classifying this 1-year misdemeanor as a person offense with a seriousness category of 7. So I present these as the recommendation of the subcommittee, with the first 3 offenses to have dual classification, the fourth offense to be classified strictly as a person offense.
Thank you. Delegate Bartlett's hand is raised.
Thank you. So I like the dual classification. I think it applies here. And I almost raised my hand on the interference with the answering point as well, to see if that needed dual classification. But I think I just can't remember, but I thought we have already a law in the books that if someone is harmed, and therefore we already might have a person classification. I'm not trying to give anybody more work, but it was just it did make me wonder when I saw it, because but then I went down a rabbit hole, and I'm sorry to have to share this rabbit hole with you all, but then I went down a rabbit hole and I thought, well, gee, there's probably a lot of crimes where it could very well be a property crime, and then it could be a person crime as well. I think with the deep fake, it's more apparent that it would be, you know what I mean, as opposed to the interference with the answering point. So I just kind of wanted to have that discussion that I've been having in my mind out loud to see if if anybody else had those similar thoughts, and if not, that's fine. I just wanted to share those thoughts. I had them during the hearing as well, so I just wanted to share that with you all.
Anyone else? Okay. Is there a motion to adopt the recommendation? One, just to recap, that
I'm sorry, Judge Middleton.
Yes.
I was trying to get off mute.
Okay.
Very quick question.
Okay.
With this AI and deep fake, are we also speaking in regards to if that individual, like with identity theft and things of that nature, if it goes to, hurt, harming them and or their family with uh, what is created in their image and things of that nature, are we looking at that as well, or are we using that as a separate offense at some doing someplace else?
That is a theft. You said a theft.
Like identity theft, where this
Okay.
where
So
AI.
Okay.
Yes, ma'am.
So this is identity fraud, but
Mhm.
is there a taking?
Yes, I'm looking at it if the individual, by the creation of the deep fake or the AI, if it causes uh, a financial um, theft and or something to them, to the victim and or their family, in the same space as identity fraud, are we looking at that as well, or is that something separate?
So this one, so if I'm correct, this Senate Bill 008, it says, when I'm looking at the fraud, it says falsely depicting or claiming to represent another person, to distribute records, that's one thing. To create credit, create or distribute records with the intent to cause harm, to induce somebody to provide information, but not to take anything. So that's why I think you just said theft. But we did earlier you speak to identity fraud, but that was used to in the elections for elections. But I don't know if
The
there
reason, the,
was
the only reason I asked is because I know many, many years ago,
Mhm.
my case is one of the cases that went to the Supreme Court in regards to identity theft and the man of the minimum 2 years for such offenses. And I just know with with this new AI that is out, I'm just wondering if we considered it. That's why I asked the question, or if it was considered during this.
Session.
Well, I think the
If I can,
legislation does refer to harm, and it defines harm to include economic damages. So I think that would
Yeah,
would plug,
again,
yeah.
I just wanted clarity that
Okay.
and in that statement, uh, as you restated it in my mind, it does go to that. So, but
Okay.
thank you for the clarification.
But you would have to be careful because that's almost creating a new crime, and you really wouldn't want to get ahead of the legislature in creating a new crime because I don't see a theft using artificial intelligence. I don't know why that just wouldn't be a theft. But you have a prosecutor here. Would not get ahead of the legislature. I don't know if you're creating a new crime. I don't know why that wouldn't be a
We'll
theft.
stay where I am. Thank you, ma'am.
Okay, thank you. All right.
Well, if I could just piggyback, because I'm confused now, so I just want to make sure. If
No.
someone is utilizing AI to then obtain someone's identity to then
Mm.
steal other goods or obtain other goods, is that not a form, would that not be considered a form of theft? Like if
Yes.
they're,
Yes.
oh, okay.
It's still theft.
Okay, so is that not what the previous man was
Yes,
asking?
and I said that is theft. I didn't say it's not theft.
Okay, I just want to make sure because I was starting to get a little
Nope, I
confused.
did not. I said do not get confused. I said that is still theft.
Okay.
Okay, thank you. Nope, I didn't say nope. All right. The last the last motion carried. Next.
So do we vote on this? I'm sorry, did
I thought that we approved. It
I
did
don't, I
carry.
don't
And then
think
the
so.
question-
I don't actually have a motion. I don't
I'll
actually
make
have,
a motion to
I actually
adopt
didn't
it.
have a person second on this, sorry.
All those in favor?
Aye.
Any opposition?
Any opposed?
Okay.
Motion carried.
All right, we're making progress. All right, so we're on to page 20, and we're now on to changes to existing offenses. So we got through all the new offenses. So we're getting there. So on page 20, we begin with, or we continue with chapters 28 and 29, which is Senate Bill 907 and House Bill 1389. This legislation, increases the maximum incarceration penalty from 5 years to 10 years for female genital mutilation, and adds to the list of prohibited acts the conspiracy or attempt to perform genital mutilation and the transportation of an individual under the age of 18 years out of state for the purpose of performing or facilitating its performance. A violator is guilty of a felony and subject to imprisonment not exceeding 10 years and or a fine not exceeding 10,000. Based on the new statutory maximum penalty and the comparables identified on page 21, the subcommittee recommends revising the seriousness category from a 5 to a category 4.
Is there a motion to adopt the recommendation?
Mr.
Thank you, Mr. Finchie. Is there a second? Mr. Harvey. All those in favor? Any opposed? Motion carries.
Moving on to page 22, we continue with chapter 426, House Bill 501. This legislation removes sex offense by a person in a position of authority from the list of acts defined as a sex offense in the 4th degree, recodifies it under Criminal Article 3-308.1, and alters the penalty structure. The bill alters the penalty for a sex offense committed by a person in a position of authority and previously convicted of a violation of Criminal Article 3-303, 3-304, 3-307 through 3-310, as well as 3-311 or 3-312, as the statute existed before October 1st, 2017, or 3-306 or 3-315, increasing the offense from a misdemeanor punishable by imprisonment not exceeding 3 years and or a fine not exceeding 1,000 to a felony punishable by imprisonment not exceeding 20 years and a fine not exceeding $50,000. House Bill 501 also provides an increased penalty for a person in a position of authority who committed a sex offense with a victim younger than 13 years old. Violator is guilty of a felony and subject to imprisonment not exceeding 10 years and or a fine not exceeding $20,000. We included 3-308.1E subsection E1, which has a 1-year maximum incarceration penalty. So we can review the full range of penalties for this statute at the same time. It will be classified as category 7 unless an alternative is proposed. For the 20-year felony, for sex offense by a person in a position of authority previously convicted of a sex offense, which is the second offense listed on page 22, the subcommittee recommends using the comparables identified on page 23, recommends classifying this as a person offense with a seriousness category of 3. For the 10-year felony, for the sex offense by a person in a position of authority with a victim younger than 13, which is the third offense listed on page 22, the subcommittee recommends classification as a person offense with a seriousness category of 4. Is there any discussion?
Is there a motion? Thank you. Mr. Johnson? Mr. Johnson, is there a motion or does your hand raise for a question?
Motion.
Thank you. Is there a second? Thank you. Judge DeLeonardo, all those in favor? Thank you. Any opposed? Motion carries.
Okay, thank you. Moving on to page 24, we continue with chapters 352, 351, and 352 related to Senate Bill 388, House Bill 898. This legislation, among other things, increases the penalties for knowingly submitting a false statement on an application for financial assistance or affecting bonding assistance from imprisonment from the penalty previously was imprisonment not exceeding 6 months and a fine not exceeding 1,000 to imprisonment not exceeding 5 years and a fine not exceeding $50,000. This is represented as the third offense on the table. Although there is no change to the penalty structure for the first two offenses, they are currently unclassified by the commission, so we asked for them to be included here and classified together. Based on the comparables that are listed on page 25, the subcommittee recommends classifying all three offenses as property offenses with a seriousness category of 7.
Is there a motion to adopt the recommendation? Thank you, Judge Shaw. Is there a second? Thank you, Mr. Finchie. All those in favor? Any opposed? Motion carries.
All right, the final bill that requires action is listed on page 26, and we continue with changes to existing offenses with chapters 131 and 132. This is related to House Bill 259 and Senate Bill 43. This legislation expands and restructures the Maryland Community Investment Venture Fund, providing that its purpose is to provide investments, grants, and other financial assistance aimed at developing opportunities for banking institutions and credit unions to better serve the needs of low and moderate income communities and extend the state's authority to match private investments through 2030. The bill also repeals certain fees charged by the Commissioner of Financial Regulation, including charging charter certificate fees for banking institutions and amendment examination fees for commercial bank. The bill also revises the definition of bank to include any banking institution, national banking institution, or other state bank for the purposes of prohibiting certain individuals from doing business in Maryland. Although there is no change to the penalty structure of the offenses, they are currently unclassified by the commission. Accordingly, the subcommittee asked for both offenses to be classified now. The subcommittee had discussions about whether to classify these as category 6 or 7. There are a range of comparables on page 27 that have 3 to 5 year maximum penalties and are either category 6 or category 7 offenses. Ultimately, the subcommittee cited the misdemeanor classification, citing that this was a misdemeanor classification, chose to recommend classifying both of these offenses as property offenses with a seriousness category of 7. Present those as the recommendation of the subcommittee.
Thank you. Is there a motion to adopt the recommendation? Thank you, Judge Shaw. Is there a second? Thank you, Judge Saunders or Delegate Bartlett. All those in favor? Any opposed? Motion carries.
Okay, for the remainder of the document, which is pages 28 through 42, there's no recommended action from the subcommittee. There's no recommended action for two primary reasons. The bills either offer no change to the penalty structure for a specific offense, and you can see in the notes what the various changes were, or there are new offenses or amended offenses with a maximum penalty of 1 year or less. And as previously noted, we have a longstanding policy. If it's 1 year or less, they'll automatically be classified as category 7, which is the lowest or least stringent seriousness category. So for those primary reasons, the subcommittee recommends no action on any of the remaining legislation that is reviewed starting on page 28. I am happy to review any specific legislation and corresponding offenses that are in the remainder of the document, but otherwise we defer to the commission to see if there's any further discussion needed.
Thank you. Judge Shaw?
So I just happened to notice as we were going through that the chapter 328, which is House Bill 1012, talking about the disclosure of identifying information kind of is akin to what we were talking about in our public for our public meetings. So maybe the staff might look at that to see whether they can get any further information that would be helpful for us.
Thank you. Noted, we will look at that.
Is there anything else that anyone wanted to discuss?
Right, seeing none, I'm going to go ahead and take the initiative to kick us off to the second subcommittee item, and that is the proposed classification of miscellaneous previous unclassified offenses. Wow, that's a mouthful. I will turn it over to Julia, who is our graduate research assistant, to lead that discussion.
Thanks. So the MSCCSP staff were contacted by criminal justice practitioners regarding 2 offenses not contained in the guidelines offense table. The first offense listed on page 1 is knowingly making a false statement to obtain a marriage license. Under Family Law, Article 2-407B, a person who violates this is guilty of perjury, which carries a maximum penalty of up to 10 years imprisonment. Based on the comparables listed on page 2, the Guidelines Subcommittee recommends classifying this offense as a property offense with the seriousness category of 4. On page 3, the second set of offenses are listed. These offenses relate to counterfeit tobacco tax stamps. A violator of creating or procuring an altered or counterfeited tobacco tax stamp is guilty of a misdemeanor and subject to up to 5 years imprisonment or a fine not exceeding $5,000. Using, transferring, or possessing an altered or counterfeited tobacco tax stamp and using a tobacco tax stamp more than once are also misdemeanors subject to 5 years imprisonment or a fine of $5,000. Based on the comparables listed on page 5, the Guidelines Subcommittee recommends classifying these as property offenses with a seriousness category of 6. The purchase of a tobacco tax stamp from unauthorized individuals is also prohibited and is a misdemeanor subject to up to 1 year imprisonment or a fine not exceeding $1,000. The subcommittee recommends no action from the commission, as this offense would automatically be assigned a seriousness category 7 property offense unless the commission wants to discuss it further. That concludes my summary, and I'll turn it over to the commission.
All right, thank you. Is there a motion? Okay, a motion to adopt the recommendation of the subcommittee. Thank you, Mr. Harvey. Any second? Mr. Finchie? Is all those in favor? Any opposed? The motion carries. Okay. Next, we have the Executive Director's report.
Okay, thank you. I have 4 items to review today. The first is related to July 6th sentencing guidelines update. So yesterday, the commission released a new version of the Maryland Sentencing Guidelines Manual and the Guidelines Offense Table that went into effect yesterday. The updates include revisions to the offense table to reflect the addition of 3 previously unclassified offenses, the reclassification of 1 offense from a property to a person offense, and the addition of 2 offenses with a maximum penalty of 1 year or less, since they may be prosecuted in circuit courts. And there are additional minor edits to the table, including a slight revision to the offense description and the correction of a statute for 1 offense. The July 2026 Guidelines e-News provides further details about these updates, and that was distributed yesterday to our listserv. The second item I want to report is on forthcoming October 1st, 2026 sentencing guidelines updates. The next round of guidelines amendments will be published in the Maryland Register on Friday, July 10th. These modifications reflect decisions made at recent Sentencing Commission meetings, including the following. First was to remove select fields from the sentencing guidelines worksheet that lack direct utility to the guidelines. Second is to expand the definition of physical victim injury, or Part C of the offense score, and to include examples of minor, non-permanent, and permanent injuries. The proposed revisions will also reorganize the instructions for scoring victim injury. And lastly, the proposed amendments clarify that an individual who's not involved with the criminal justice system for the purposes of calculating the offender score, if the individual's only involvement is to comply with the ongoing reporting requirements associated with sex offender registration in the state or elsewhere. We all discussed this at the most recent commission meeting preceding this. This is not a new guidelines rule, but rather we provided additional instructions to provide clarity to practitioners. After the proposed revisions are published in the Maryland Register, they are expected to be finalized and adopted effective October 1st. The third update I want to provide is an update on the timeline for our prior record study. As you all know, and at the May meeting, I provided an update regarding the timeline for the study. We haven't gotten too much further. I noted that there was initially a lengthy delay with getting the data, and that we did receive it in January. However, the data we received had significant missing data issues, and the Sentencing Commission staff worked with staff from Public Safety, and they provided an updated data file. Unfortunately, we identified some further issues with the updated data, so we still don't have a workable data file that we can analyze at this point. Specifically, it's issues with offense identification, which is critical to this particular analysis. So we're working with Public Safety. We just met with them again last week, and we are hopeful that we can find a resolution here soon to address the data issues. And I will plan to provide a more definitive update to the timeline for the project once we have a data file that we can do to accurately identify the offense information. Finally, I just wanted to report good news about the staff vacancy. I noted in May that the staff had been working to fill our vacant faculty specialist / research assistant position. We had approximately 150 candidates who submitted applications for this position, which was amazing. Probably a sign of the times about the current job market. Also meant it was a lot of work. We were encouraged by all the interest in the position, but it also meant it took a lot of work for us to go through all those applications. But we did narrow it down to a final group where that was interviewed by the search committee, and then final interviews with a smaller group with myself. And I'm very happy to report that as of today, we do have a candidate who has been offered and accepted the position. And we are expecting this individual to start on Monday, July 27th. So I look forward to introducing the selected candidate at our meeting in September. I do want to just take a minute to thank the Sentencing Commission staff. The University of Maryland has very formal procedures for hiring, which are good. But we have a search committee, and that was chaired by Stacy Najeka, and the other members were Sarah Bowles and Catherine Pembroke. We have a small group, so all of us participated in some way. But there was a lot of work to go through 150 applications, as you might imagine. So I did want to just genuinely express my appreciation for all the work. And I think they did an amazing job identifying some qualified candidates, and ultimately the candidate who we selected, who I think is going to be a great fit for us. So I'm really happy about that process, and that we'll be able to introduce them, and we'll finally have our new staff person starting at the end of this month. So that is it. That concludes my report. I'm happy to address any questions.
About that data set you're waiting on. Problems with the data that just generally with what you've received, and if we're not able to get the data set, what are the potential we can conduct that review?
That's a good question. We're hopeful that we can get that information into that. Right now, the volume of missing information is significant. We're looking at around 40% of offenses that don't have accurate offense identifiers. There is an offense literal description field that can be used. It is problematic because it allows for the data entry of the offense name to be written any way the individual who is entering it chooses to do so. So, for example, second-degree assault might be described 1,000 different, well, not 1,000, but 100 different ways. So we would have to we'd have to go through and write code to identify all those different identifications and categorize them correctly as the same offense. So it is a tedious process that we're hoping to avoid by getting accurate offense identifiers. They should be accurately identified. We're trying to figure that out, Rick. I don't have great answers. Hopefully I will by the next time we meet. But it's critical for this evaluation to know the specific offenses. That's really what we want to be looking at, and determining how the prior record is being scored, right? It's offense driven. So we need those identifiers. It's been a bit frustrating, as you can probably tell by my tone, but we'll get through it. It's just taking a little bit longer than we expected. Any other questions? Okay, I'll turn it back over to you, Judge Saunders, excuse me, Judge Middleton. I just pointed a new chair there on the fly. Sorry about that.
I was going to say, Judge Saunders, hit it. Hit it, Judge Saunders. All right. So the remaining meetings. The next meeting will be September 15th, Tuesday. That will be virtual. And then November the 30th will be our in-person public comments meeting. Is there any old business? Any old business? Any new business or announcements? Any? Okay. Well, good work, staff, in identifying someone, sifting through all of those applications. Excellent work. And I hope you all enjoy the rest of your summer.
Yes.
Hopefully you find a way to stay cool. See you next time.
All right. Thank you, everyone.
Good
Appreciate
night.
everyone's time.
Thank you.
Thank you.
Bye.